Welcome to the LaunchPreneur Experience, Legal Edition. I am Felima Farman, your host, a summit and launch strategist and international speaker. And today I'm here with Nuzayra, who is my almost next door neighbor. She's like an hour and a half away from me. And I'm very excited to interview Nuzayra. She's a business and intellectual property attorney. So in our conversation, she's going to talk about how to set up your business up for success by leveraging your intellectual property. Very important conversation. Welcome, Nuzayra.
Hi, thank you so much for having me here. I'm so excited and honestly really honored. And thanks for the great introduction.
Yeah, thank you. So can you share a little bit about your background with the audience so they can really feel like I need to watch this interview until the end?
Absolutely. Hi, everyone. My name is Nuzayra. I'm based out of LA, but I work with clients nationwide. I'm a business and intellectual property attorney. And my area of focus, or you can say zone of genius, is helping online business owners, such as yourself, protect their intellectual property assets. And then also I work with them on scaling strategies. So whatever assets that you have in your business, those assets can be scaled. But oftentimes we don't even look at our intellectual property and think that, oh, these can do something. We often think of them just as nice certificates that you hang on the wall. That's not the case. So that's what I help my clients with: brand and content protection in the online space. Before I started my own practice, I used to be a senior IP attorney here in downtown LA. And I worked with clients from all walks of life that you can think of. So tech, cannabis, fashion, entertainment, anything that Southern California has to offer. I worked with these companies and I would work on with them again on how to protect their IP assets and then scaling strategies. So yeah, that's a bit about me in a nutshell. I always get lit up whenever I'm talking about intellectual property for online business owners because I feel that it is something that needs to be talked about more. It's something that every business owner should know about because it is your asset. And you should also know how you can leverage your intellectual property. It's not just enough to know that you have intellectual property. It's what you do with that is what's going to make a difference for your business. So I hope you will enjoy the conversation we're about to have.
Oh, thank you so much for the introduction. And yes, so today we're talking about terms and conditions, we're talking about privacy policy, and we're talking about how to protect your content and monetize with copywriting. So one of the things, the first thing, I guess, is my question is, what is intellectual property? Because when I got started and somebody asked me, did you protect your intellectual property? When I got cloned, when somebody copied me, and I'm like, what do you mean intellectual property? And I had no idea what that meant. So would you please tell us what that is?
Yes, absolutely. I'm so glad you asked that question. So intellectual property is something that, again, every business owner should know about. You should know the main types of intellectual property because it will help you decide the strategies for your business. So in a nutshell, what intellectual property means is what the name suggests. It's property. So it's property of your business. And it's from here. So intellectual property, it's property that you cannot touch, you cannot feel it, but it's very much there. It's everything that you create. So there are three main types of intellectual property, and that is going to give you an idea of what we mean when we say intellectual property or IP. So the three big ones are trademarks, copyrights, and patents. Trademarks are there to protect your brand's identity elements. So basically think of your business as a separate person. Just like you have a name, you have an identity, people will call you by a certain name. If they want to find you, they will know, okay, I have to type this person's name on my phone and I can find this person. The same way your business has their own identity. And what a trademark does is protects your brand's identity element. So the name, logo, if you have a tagline, if you have a unique color associated with your brand, a unique sound, even a unique smell, all of these can be trademarked. So that's one type of intellectual property. The second big one is copyrights. So just like trademarks protects your brand's identity, copyrights protects what you create. So all of your original creations are copyrightable. So think about a song. There's so many copyrights in a song. You've got the music, the lyrics, you've got the and beats. And if there's different people involved in making that music, all of the creators, all of the people that contributed towards that music are copyright owners. To put it in context for online businesses, think about the graphics that you design, the ebooks that you come out with, the content inside your online courses. Everything that you've created that has come from here and you've put it down in a tangible form. So you've put it down in the form of a book or of a recording, copyrightable. The third big type of intellectual property are patents. Patents are there to protect your inventions. If you've come up with a technology that is about to change the world and revolutionize how we as human beings behave, that is a far-fetched definition, but you get the idea. Something that is new, something that has not been thought of before are patentable. So it's usually related to inventions, or it can even be that you're improving on a particular invention that can be patented. So these are the three big ones. Then you've got trade secrets, which is a special type of IP. So all of these three IPs that I mentioned, trademarks, copyrights, patents, in order to get maximum protection and benefits, you have to register these intellectual property assets with the relevant government agencies. So for trademarks and patents, you go to the USPTO. For the Copyright Office, you go to the US Copyright Office. However, trade secrets are a very special type of intellectual property. It's a type of intellectual property where the value of that property is in its secrecy. If you reveal it, then the value is gone. And if you register it, any type of IP you register is public information. It's there for the public to see that you own this particular property. So the idea with trade secrets is it's valuable, but it is so valuable that sharing it is going to decrease its value. Best example, recipes. Coca-Cola, KFC, all of these, or McDonald's, fries, the famous hamburgers from McDonald's, all of these famous recipes where you will wonder for the rest of your life what the recipe is, but unless and until you belong to that special group of people, there's probably, I think someone said that for KFC, it's probably only 3 to 4 people that actually know the recipes. The recipe itself, the mix of ingredients, what makes KFC taste the way it does is a trade secret. It's not registered anywhere, but it's kept in top-notch condition and it's protected by contracts. So whoever has access to that information, they have to sign an airtight non-disclosure agreement or an NDA in order to protect the secrecy of this recipe. So that is in a nutshell what intellectual property is.
Okay, that is awesome. Thank you for breaking it down so easily and giving us examples, because that makes sense. It's easy for us to understand and assimilate to what we do today. And one of the things we're talking about, off air is that in the past, I thought that copywriting was just having like the little sign on the bottom of my page and just saying it is copyrighted because it's public information. But just because it's public information doesn't mean that it's protected public information. So when they try to protect, like if we try to protect all of those aspects of our brand, like the logo, the name, the tagline, the colors, the copywriting, those are all separate files that we have to do, right? Each one of them is a separate file, right?
Yes. So for trademarks, it's a bit different compared to copyrights. The way the application is done is a little different. So for trademarks, you're absolutely correct. The brand name, the logo, the tagline, these are all individual trademarks of your business. So they all have to be filed in separate applications. Copyrights, on the other hand, slightly different. It depends on the timing that will determine how many applications you need. So generally, if you have an ebook, for example, that entire ebook can be one copyright application. If the ebook is not like 5,000 pages, then you need separate copyright applications because there is a limit on how much you can upload as a deposit. When you are submitting a copyright application, there's a limit. But generally, ebooks are one copyright application. What makes a huge difference is online courses. And I'm sure a lot of folks who are watching this you either have an online course or you might have an online course in the near future. So this is really, really important. Online courses have written materials. They also have video instructions. Most of the time, you'll have a video just like this. So for the written materials, you can put all of the written materials as one copyright application and submit it. But you cannot put written materials, videos, all of it under one application. That's not how it works. The videos have to be a separate application. Now, where it makes a huge difference is the timing of when you file. So say you have an online course, but you haven't launched yet, but all your materials, everything is ready. That's a great time to file your application because now you can bundle up all your videos in one application and all your written materials in another application. So you're submitting essentially two applications, which are cost effective, they're easy to monitor, they're great. Say you decide, no, I want to see if this course even does well. Why should I bother paying the Copyright Office any fees? I want to first see how this course performs. So you launch your course. As soon as you launch your course, the course is deemed published. The rules for unpublished and published work, different. So as soon as you launch the course, now all your written materials can still go under one application. However, your videos, each video is considered a published work. So each video has to be done separately. So if you have 10 videos, which unfortunately happened to a client of mine, if you have 10 videos, just because of the timing, you could be looking at 10 different applications versus one application. So yes, it depends. It completely depends on the type of IP that you're applying for and your strategy around it of how many applications need to be filed.
That it's amazing. That's an amazing information because, a lot of us, what we do is we're testing the waters before we invest the money, right? But then if that works, as you said, then now you're going to be spending or investing more because you didn't trust on that on the first place. And that's where it's so important to actually start small and kind of seeing what people like, what your audience needs and wants, instead of you just thinking, oh, I think they need this. And I'm just going to make all of those videos. So I'm going to make all this course because that's what I think they need. But actually, that's not what they want. So it's very important that you understand your audience. And I feel like, okay, when it comes to online courses and online events, one of the things that a lot of us leave behind is we're driving all this traffic into one page for registration, right? With the online events, we're going to have an event. We wanted to have as many people as possible register for that event. And some of the events are free, some of them are paid. And when we create that page, some people are doing organically and some are paying for ads, which means we're talking to people all over the world. It's not just United States, which means rules apply. Even though you're in the United States, you need to abide by rules from different countries as well. And what is that you think that it's important to have in that landing page when people come to an event, so they are protected in terms of registrations and like how you collect their data, how you use their data. This is a free program, but it's actually, we're going to charge for you later on. What do you see that's important to have on that page?
That's a great question. So there's multiple moving parts here. We're going to go into contracts in a little bit because this is essentially what contracts are for. But even just from a copyright perspective, when you are designing a landing page, and you've put in graphics and you've put in, when you're designing a whole funnel and your audience is going through each step of the funnel, they land on the landing page. All of that, by the way, is copyrightable. The whole graphics that you're creating. This will help if someone is copying your entire funnel or just copying your designs and templates. Yes, that's when this comes into handy, because now this is copyright infringement. And it's copyright infringement even if you don't register. However, if you don't register, you have an uphill battle. Registration, copyright registration allows you to claim yourself as the owner of all the graphics and templates and landing pages that you've prepared. It also allows you to have much higher level of protection and much higher level of damages. So if you see someone participated in your virtual event and you see them literally just taking your templates and they're putting it up on social media everywhere, you're telling them, hey, Susie, do you mind taking that down? This is not cool. I prepared all of this. And Susie says, nope, thank you. Now, generally, what can you do in a situation like that? You can keep messaging this person. This person can just block you, and that's it. End of story. But if you have copyright registration, you can submit an IP violation claim with that certificate to Facebook, to Instagram, or wherever on earth they're hosting that. So it could be ClickFunnels as well. And under the law, basically under DMCA, all of these institutions such as Meta, such as ClickFunnels, they have a responsibility to investigate. By law, they're required to do it. So they can even take down all of that infringement pretty much overnight. This person's entire situation could be gone. Like the landing page could be gone, everything could be gone. So it is a powerful tool to have in your arsenal, I would always say. It depends on you as the business owner on whether or not you want to take that measure and you want to pull that trigger and take down someone's entire listing, because it does hurt them. Financially, it'll hurt them from a business standpoint, but you have that option to do so. You also have the option of collecting, if this goes to court, for example, you have the option of collecting your attorney's fees from the infringer. Attorney's fees are huge. IP violation lawsuits can run into six figures, multiple six figures. And if the other side is paying for your attorney, well, that's a huge relief. You can even go to an attorney on and tell them that, instead of billing me by the hour, can you take this case on contingency? So you get paid once the amount is recovered. Generally, attorneys don't like that unless they know there's a sure shot chance of winning. And when they see you have your copyright registered, they know, oh, it's registered. That means I can collect attorney's fees if we win. Plus, you also get really high statutory damages. When something is registered, when a copyright is registered, the court has a discretion to award you up to $150,000 per intentional infringement. So intentional starts as soon as you tell this other person, hey, you're using my work without my permission, this person has been notified, intent is established. So as long as they keep that infringing material up there, every day they could literally be on the hook for that amount of money incurring every day. So that's from a copyright perspective. Now, once you have your copyrights registered and everything, then you can certainly put that C mark, and that C mark will make a lot of sense, and it has relevance at that point because you have it registered. And now you've put it as a notice for the world to see that, okay, this is all registered work, do not mess with this. So that is step one, which is the copyright part itself. Step two is when you are bringing so many people into your world and you are collecting sensitive data, you have to comply with privacy laws. It doesn't matter what part of the world you're in, the privacy laws apply. So people are coming onto your landing page. At the very least, they're giving you their first name, last name, email address, at the very least. Now, would you consider this sensitive data? Answer is yes, it is, because it allows you to identify someone. If you can identify someone with any kind of data you're collecting, that is considered sensitive data, and it is under GDPR. And if you're in California, it's under CCPA as well. So when people are going to your landing page and they're signing up, it is highly recommended that you have little links there right at the bottom, which says privacy policy and terms of use. And you'll see on a lot of landing pages, they'll have a little box that says, I have read and I agree to the privacy policy in terms of use. So you have to check that box in order to submit. Sometimes, most of the time, even I'm guilty of it doing it sometimes, don't read what's in there. Yeah, you just check that box and you're like, this is fine, which is fine. Most of the time, businesses have good intent. They don't plan on, harvesting your data and doing malicious things with it, but there are times they can do it. And this is all in their terms of use and in their privacy policy. So the privacy policy is there, not so much for your protection as a business owner, but it can. It's there more for people who are giving you their information. So by law, so there's two big privacy laws. One is GDPR, the other one is CCPA, which is fairly new. GDPR is very interesting. It came out of the European Union, but it applies throughout the world, because the law is that if you're collecting data of European nationals, you have to comply with GDPR. It doesn't matter, say you're in San Diego and you have no intention of getting the data of someone who's sitting in Spain. But if this person can access your site and give you their information, that's it. Now you have to comply with GDPR. Similar with CCPA is if you're collecting data of California residents and it's a large amount of data, then you have to comply with CCPA. But privacy policies are so required, and that's why they've made it mandatory, because the privacy policy basically tells the person, what are you doing with their data? Why are you collecting it? What's your end goal here? Are you going to sell their data? If you are going to sell their data, you have to disclose it. And you have to tell them, who are you selling the data to? Who are these third parties that are going to have access to your data? And the privacy policy will also have information such as, if you are concerned about how we are using your data, this is the email address, this is the phone number where you can contact. If you want us to delete your information, how do you do that? You opt out, you unsubscribe, but there's also a customer service contact information here. So that is all there for people to see how you're using their data. Mm-hmm. And because this is mandatory by law, if you don't comply with this, unlike a terms of use, which is not mandatory by law, but a terms of use is there more for your protection. If you don't comply with a privacy policy, you can actually get into real trouble, because the Attorney General can bring a lawsuit against you, including ordinary citizens. So this is really scary, but it can happen if someone, and there are data trolls, they're literally called data trolls. They go on the sites of established business owners, and they see if the privacy policy is up to date and compliant with current laws. If they see that no, it's not, they can actually bring a lawsuit against that business for not following GDPR or CCPA laws. So it's very important that you put that little link at the bottom of your landing page, just to tell people, hey, this is where you can go check out the entire privacy policy, see how we use your data. And if you have any questions, this is where you can reach us. So that's privacy policy. And in the end, you have your terms and conditions or terms of use. This is a contract, just like a privacy policy is a contract between you and the people who's giving you their data. The terms of use is also a contract between you and the people that are giving you their data, or if they're buying from you. And terms of use or terms and conditions, this particular contract is not mandatory by law. But if you don't have it, you are basically hurting yourself, because this is the one place where you can tell people what your policies are. What's your refund policy? What's your cancellation policy? Et cetera, et cetera. How can they pay you? If there's a dispute, how do they resolve it? So they don't just do chargebacks, or they don't just go file a lawsuit, but they actually have a procedure that they can follow. So those are the three big things that you want to keep in mind when you're launching online events: copyrights, privacy policy, terms and conditions or terms of use.
Oh my gosh, I just feel like, woo, that was amazing.
I know that was a lot.
Yeah, there's a lot to digest. And I know that if you're like me, that I'm always hosting events, you might be opening yourself for some trouble in the future. We hope not. We really, we would like to think that people are nice. They understand what you're doing. They're not going to report you, but you never know when your competitor or something that's upset with you or a past client that just say, you know what? That's how I'm going to get back to them. And that
Mm-hmm.
happens. So one of my clients, she had actually somebody that came back to her because she was doing this free event, but she had an offer. At the end of, during her free event, she had an offer. And this person actually came back to her and said, nowhere in your website, in your email marketing, anywhere it says that you are going to do an offer. It says was a free event. So since you made an offer to your $12,000 package, coaching, that has to be free. And she's like, no, it doesn't have to be free. And she's like, well, nowhere says you're going to charge for it. You said that this event was going to be free, that you're going to teach me this A, B, and C. And now you're selling me this coaching package to teach me that. So the language on the website, on the landing page, was in a certain way that, yeah, but we all know with good intent that that's not the case, right?
Mm-hmm.
So this lady came to her, and we don't know if this lady was going to file a lawsuit or if it's just, talking, but she talked in a way that it sounds like, I know what I'm doing and I want your course for free. So it was not a one-on-one coaching, it was a course that had the one-on-one, part of it, which is like, at that point, do you really want to show up for that one-on-one after you do that? But she actually got the course for free, and she had to sign a contract saying that she understands. So they had to come into an agreement. And my client just said, I'm just going to give it to her because I don't want this to go any farther. And then after that, she started having the disclaimer on the bottom that says, this is free. It's not another thing, it's not associated with Facebook, which we have to put that in every single, promotional material that we are putting out there, because if you're hosting that event inside a Facebook group, you need to say, Facebook is not associated with my event, which we know they're not, but it has to be a disclaimer on the bottom. But anyways, put in there that you will be offering anything that, you're going to be doing during this event. The results are not typical, right? Because we had somebody saying, well, in your program, the catch name was 30,000 in 30 days. Well, and you show people that are doing 30,000 in 30 days, but I didn't make 30,000 in 30 days. And that's how I came to your program. Well, then you need to know that everybody's different. So you have to put that on the disclaimer as well, saying, this is not typical. This is, everything that you're going to be doing here requires work, because it's not just having an idea and making 30,000. So can you talk a little bit about the, what you have seen in terms of people really getting back and, kind of suing those, those online event hosts that are out there?
Yeah, absolutely. And you've brought up such a great point. So it's so important in your contract. So that's why I was saying earlier that terms and conditions, terms of use, they're not mandatory by law, but they are there to protect you. And if you don't have them, then you are opening yourself up to all kinds of liability and very expensive lawsuits too. So when you are preparing your terms of use, your terms and conditions, you want to think about likely scenarios that can happen, because no two businesses is the same. However, some similar incidents can happen to people, for example, who are coaches. A lot of coaches, obviously, when they are promoting their services and they're promoting their packages, they are going to put up testimonials of clients, or they're going to put up case studies where it says, yes, this person made $30,000 in 30 days by implementing my strategy. That's great, but that's a promo. That's not something you can guarantee, and you should not be guaranteeing it. If any coach is saying, I guarantee this is going to happen, you need to run the other way, because that just that's not how business works. And that needs to be reflected in your contracts. So I work with a lot of course creators and online coaches, both business coaches, life coaches, health coaches, more so business coaches. I work with a lot of business coaches, and in their contracts, one thing that we always put in, and it's like a nice big section, which takes up almost one page, are these disclaimers. Disclaimer that any kind of promo that you heard, it depends from case to case. That's just a layman's terms of saying this, but we obviously want to put it in legal terms. But what you're trying to tell the person is a result is not guaranteed. What is guaranteed is you're going to get access to these materials, these tutorials, and you're going to get access to my mentorship or my team's support, and we're going to help you and guide you. However, the outcome of this program for you is going to be very subjective. It's going to depend on how much effort you're putting in, what you're doing, how you're showing up, because this is not like buying a piece of candy that, okay, if I give you $5, I'm going to get this particular candy, and I know this is it. This is a service, and this is a business outcome. So you want to have that in your terms and conditions. You also want to have disclaimers which says in what scenarios you will or will not issue refunds, or you won't respect cancellations. And you can put it there. Like, we've prepared, we're launching this contract template store. So we've prepared all these contract templates that people can take and start using. But in order to prepare that, we obviously had to understand what kind of situations people, coaches face, or online course creators face in their day-to-day business. Some things during our research that came up quite a bit is people would tell you, and I interviewed my clients too. I said, can you just give me 10 minutes of your time? I just want to hear what have been the most ridiculous things you've heard from people who wanted their money back. And some of the things we've heard is, oh, I don't feel aligned anymore. That is very vague. That means absolutely nothing in legal terms. It can mean a lot as a coach. If someone says, I don't feel aligned with your strategy, okay, that makes some sense in that world, but still it's too vague. You can't pinpoint and say what doesn't feel aligned. Other people have said, I have decided to implement different strategies now. Okay. Other people have said, this does not call to me. These are literal, and my clients have shown me emails. Like, these are literal emails they received asking for a refund, and this is the reason. Now, none of those reasons, if you don't list them out in your contract saying, these are not good reasons to ask for a refund, guess what? They become very good reasons to ask for a refund because you have no policy. So we've put them all in the contract. Like, these are scenarios. You cannot use these as excuses and say, I want a refund. The only way you're going to get a refund is, and then you put in your very specific condition. What is the condition? The condition could simply be that, okay, we've signed on to work together for 3 months. You've decided after working with me in the first week that this is not working out. That is fair. Then you keep 1 week's payment and you refund the remaining payment if you want to. However, it's completely up to you if you also want to have a no refund policy. As soon as the work starts, there's going to be no refund. I have that in my contract. A lot of attorneys will have this in their contract because of experiences we've had where if you leave a refund door open, people will come back to you and ask for refunds on the most ridiculous grounds. So now, even in my contract, when I send a contract to a client before we start working together, it clearly says that once we've started working on your matter, so once we've sent you the first questionnaire or we've done the search, anything, you cannot get a refund anymore. This is it. You are now dialed in. Because a lot of the times what people would do is they would start working and then all of a sudden they get buyer's remorse. Oh, this is not going to happen. This is too expensive. And it's not just with attorneys, with any service providers. Mm-hmm. You can have that and they'll come up with these excuses. It's your job as the business owner to identify, okay, what are excuses I've heard before? What are possible excuses that can come up? And if they are actually excuses and you feel like they're not reasonable, definitely put them in your contract and say you cannot ask for a refund based on these grounds. And if you do want to ask for a refund, then here's the way to do it. You give them the exact steps they need to take. You need to email this address, or you need to set up a call. You have to do that before certain dates or certain events happen. So yeah, I would say it is like the most important contract in your life as an online business owner, your terms of use that you have with your clients, and it's there for your protection. So use it to the fullest extent cover as many scenarios as possible, but you also don't need to think of every scenario under the sun. You can have like 3 to 4 main bullet points that you see come up a lot, and then that's it. You're good. And as you go along, remember, contracts are, I always like to say, your contracts are living and breathing. They have very much a capacity to change. So you can amend it. Don't think once you have a contract, this is it, nothing can be done. No, they have a capacity to be amended. They have a capacity to land you in trouble or get you out of trouble. So as you go along and you come in contact with more people and you learn more, you experience more, amend your contract to reflect those changes. You should be good.
Yes, I love that, because we, as you said, we can never imagine every single situation that's going to happen. With one of my clients, what happened is this lady had a baby and she said, I need to get a refund 6 months later because I had a baby, and your coaching calls are in a time that I cannot be live. And I feel that if I'm not live, I'm not going to get the best, because I can't get, you either have to give me a different time where I have access to you, or you need to cancel. And that coach was not going to do a one-on-one. It's a group coaching program. And the only way that she was able to win, it's because this lady, in 7 months since she joined, she actually only showed up 3 times for the live calls. And she had the records for that. But like, I just had a baby, now I can't sleep at night, so I can't be up at that time to be on the, and it's like, I don't even understand where those things are coming from. But as you're saying, you give them the only way you can do is by this and by this date, which I feel like is very important when you say you have 14 days, because a lot of the coaches will open their portals and here's all my content for you, right? So they come in, they have 14 days, and people start downloading the program and just download, and then they cancel.
Yeah.
Which happens as well. So having that date, and one of the things we're doing now, it's, one of my clients, is that we are actually delaying. There is like a progress where you come in, and of course you wanted to, trust the people that you're bringing in. Otherwise, why would you bring them in if you don't trust them, right? But at the same time, you need to understand that with what's happening in the online world right now, it's kind of a wild west, with new coaches copying new coaches and learning how to be a coach from a coach that's learning how to be a coach. And there's like so many people are copying and then changing 10% of it, and now it's their own.
Yeah.
There's that percentage that you can change, and then you make it your own. You add one little tweak to it, now it's yours. So getting yourself protect ahead of time with the copywriting, before you put your ideas out there, because that happened to me. I shared with somebody how I host my events, what I did, and how I make it special. And she went ahead and she actually copied that. And I know she was not doing that before, because I saw some of her events before. So, it was my responsibility to put that word out there. But ignorance is not an excuse, right? I was ignorant to this topic, and that's why I hold this topic so dear to my heart right now. And I wanted to make it accessible for everybody to listen to this, the possibilities and the solutions as well, and where to look for help and what to look for help. Like, okay, at this point, I need to trademark my slogan or my tagline, because that's what defines my business. Or actually, it's my logo that is so unique that I want, like Nike, right? That's like, you see that, is like, wow, I know. You don't need to say anything else. I know that's Nike. Coca-Cola, the red, or Tiffany blue. We don't say, nobody knows what's blue, but you will say it's Tiffany blue. Then immediately you recognize that brand as Tiffany, because it's branded to them. We can use it, but we all know this is Tiffany blue. So having that understanding of where you want to go with your brand, how important it is for you when you trust and you really have that passion and you feel like this is right, before putting out there, finding somebody like Nuzayra that, you know, an attorney that can support you and say, okay, this is the best way you can do. This is, you know, even if you're limited on, you know, cash, because a lot of us, when we're starting,
Mhm.
like we have an idea and like we're talking about before, what do I do first? Or
Yeah.
is this really going to stick? Let me try it out first and see if the audience likes, and then I will go ahead and make this, you know, brandable and, you know, trademark this. And that's when you get unprotected. And that's when you get a letter of, oh, you have been using your own name. Now you need to change it. So, and that's, you know, it happened to me with, I was using a name and I had already invested on a website and I was teaching people how to use a particular software. And I was, you know, one of the only ones back then. So the
Mhm.
company that I was promoting their software, and I'm saying, I'm telling them what the name was of the software, but I didn't use their trademark and their register, the R on the top.
Mm.
I just didn't know. So they came after me and I had to let go of everything. And because they are a corporation with over 5,000 employees all over the world,
Mhm.
I know they have the best lawyers. Do I want to fight? Just that fear,
Yeah.
just like that bad, you know, energy, like, oh my gosh, I'm being sued. I need
Mhm.
to let go. And I invested all this money. It was, to me, it was worth to let go and to have
Yeah.
the peace of mind. But that was, you know, what I built my business on. It was painful, but at the same time, you know, it's gone. And I've seen people using it, but they actually have the R, which I didn't know. If I had a lawyer with me back then,
Yeah.
just to advise me on say, no, you can still use this. You just need to change this and, you know, make it use the language that shows, I could have continued my business. And
Yeah.
somebody else picked up that name later and did the right way, and they're using it. But I'm not in that industry anymore. So there's no remorse, but it's just a lesson that I learned how important it is to have somebody on your back end, like build that relationship with a lawyer that will support you when something like that happened. Don't just throw the towel and say, okay, this is it. I'm just going to move forward because it's too costly. But actually talk to a lawyer. You might be able to save
Yeah.
your business, to save your brand. You know, there might be options out
Yeah.
there and you don't know.
Absolutely. And, you know, just to add to that, I know a lot of people, especially when you're starting out, you do feel nervous about going and talking to a lawyer because the idea is that lawyers will charge you by the hour, right? That's the normal conception. But it's changing now. A lot of attorneys, including myself, and I know many other attorneys, we offer flat fee. There's no hourly billing, it's subscription based, it's payment plan based. So when people come in and they genuinely need help and it's just the finances that are getting in their way, at the end of the day, you know, lawyers are, you know, human beings too, and we're all trying to run a business. So when you can share your concerns, the person on the other side who's also a business owner, they can relate, they can understand. Like I understand when my clients tell me like, oh no, you know, I cannot pay all of that up front. That's totally understandable. That's why so we will break it down into payment plans. But the idea is not only, I think for attorneys, most of the attorneys that I know are good-hearted people. So the idea is not only, oh my God, how can I bill the most? How can I get the most amount of clients? But it's also like, okay, am I genuinely making a difference in someone's life? Like, am I helping this business? And that in a way acts as a great testimonial for us too. Like if I'm able to help a business owner avoid a disaster situation, the chances of that business owner going and telling three other friends about me is much higher than if I just go, no, you know, you either pay this or you're out. So it doesn't, you know, it's not even like that anymore.
Yeah.
Yes, if you go to traditional law firms, they still have that strict entry point. But now you can have attorneys in your in your roster. Basically, if you have a coach, you have an accountant, you need to have an attorney there too. So just so that at least at the very least, you can email them and ask them a question or just run something by them to make sure that you're not headed into a train wreck, just straight up. Like you can avoid that situation and yes, save your business. And sometimes it just takes small tweaks. Like if you're using someone's brand for example, all it would need is a language, like one sentence disclaimer that, we are not associated with this brand. This brand is owned by, and you name the corporation. So when the corporation lands on your page and sees that disclaimer, they know that, okay, this business owner isn't trying to fool people into thinking they're working for us, but he or she is literally saying that this trademark belongs to this other business. So it's just these minor tweaks that can really help your business stay in business and stay profitable. And a lot of the times, attorneys or accountants or these types of professionals that actually have to go through a whole stringent licensing procedure, there's a reason why they have to, or we have to go through all of that, is because the kind of advice we can give we can only learn this from years and years of schooling and experience. So it's not something that you can often Google. Like, you can't Google these things. Like, oh, how do I make sure I don't get sued by this company if I'm using their brand? Like, type that into Google, see what comes back up. It's not going to be very helpful. So, don't waste your time. I think that's one piece of advice that I'm going to give to online business owners who are watching this, is that there are places where you can do your own research, save money, and be scrappy. And I recommend that, because when I started out, I was the same. But there are places where if you try to do that, it's actually going to hurt you, because you don't know. You haven't gone through the bar exam. You haven't dealt with other companies that have brands. You just don't know what you're going into. So just copying someone else's thing and saying, okay, this person has used this particular disclaimer on their site, I'm just going to grab that and put it on here. You have no idea what you're putting on there. So yeah.
That is so true, because it happened to me. There's a lawyer that I know that I was just sharing, my contract, and he did like an audit. And then at the very end, it said the Commonwealth of California. Well, California is not a Commonwealth. And he said, oh, did you copy this from somebody? And I'm like, yeah, my friend gave me her contract so I could, use and just use a different language. Well, she's like, I think was in New Jersey where she got the contract from. It's totally different than California. Yeah. So, by using somebody else's contract, I was not protecting myself. And of course, that's one of the parts, one of the things, but there's other language in my contract that California, it's different than other states. So just copying, it's not the best way. And I know when you're on a budget, but you know what? Today, lawyers have contract templates. They have, like so many ways, the entry points that are low entry points for you to get started and protect yourself. And it's important. Like, it's very important. We are putting ourselves out there daily when we're doing business online, and you don't want to have your brand changed overnight, because that costs a lot of money to redo all your branding or your message. And now people are doing search for you on Instagram, and they're going to your competitors because now it's not yours anymore, right? Exactly. So you really want to think about how you're positioning yourself as a leader online, and what do you need. This is a cost of doing business. I don't see it as an expense. It's basically like you're saying with the membership. We pay membership for everything. You pay membership for Netflix because you want to get your mind out of something. What if you want to really get your mind out of give yourself a peace of mind? And that's a membership for peace of mind, right? It should be saying peace of mind membership. So legal peace of mind membership. So I love everything you shared. Thank you so much for your time, for sharing with us your expertise. And you have an amazing gift, which is a trademark and copywriting gift. Would you please tell the audience why they need to get that gift?
Yes, absolutely. Well, the trademark and copyright guide is absolutely essential for any online business owner. It easily breaks down. So I explained in brief what is a trademark, what's a copyright, but it easily breaks down the concept, and it helps you as a business owner identify those assets within your own business. So it's a little fun thing that you can even do on your own. You can sit down and, make notes by yourself. If your brand has not launched yet, if it's not public, then definitely do not share that. But otherwise, it's an awesome way for you to learn about trademark copyrights in an easy to understand way. And you can just do your own homework and identify those assets. And that gives you kind of like a roadmap. When you see that down on paper, what are the assets that you have in your own business? Then you understand that, oh my God, I have all of this. So I need to protect it and I need to strategize. So that's one of the reasons that I offered this gift. I really hope you guys enjoy it.
Thank you so much, Nuzayra. I appreciate that. And hope to see all of you inside. And make sure to connect with her, follow her on Facebook or, in her social media, see what she's up to and learn. And I hope you enjoyed this interview. Bye.
Thank you so much. Bye.